rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. Good morning, everyone. It's great to be with you. Thank you for having us here at Baylor. Thank you for braving this beautiful weather that we're having to be with us here this morning. This is a beautiful facility that you have, and we are honored to be with you this morning. Thank you to Dean Counselor and to everyone else here at Baylor who has made it possible for us to be here today. Article 5, Section 5B of the Texas Constitution allows the court to meet at locations outside of Austin. It specifically authorizes that, and we try to go on the road once or twice a year and give Texans around the state an opportunity to see what they can see in our courtroom on a regular basis, but often don't get the chance to see. And we're happy to be with you, and I think we'll get started. We'll hear argument in two cases this morning. The first is 23-0167, University of Texas, Rio Grande Valley against Oteka from Hidalgo County and the 13th Court of Appeals. The second case is 23-0955, Walgreens versus McKinsey from Harris County and the 14th Court of Appeals. The court has allotted 20 minutes for each side in each of the cases, and we will take a short break in between the arguments. And after the second argument, we'll take another short break, and then we'll come back and have an opportunity for you to ask us some questions and talk to you about what you just saw. We're ready for argument in 23-0167, UT Rio Grande Valley versus Oteka.
May it please the court, Ms. Tripp will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, if it pleases the court. The question before the court today is whether an injured employee can circumvent the Texas Workers' Compensation Act when she sues her subscribing employer in negligence, while there is a question of whether the injury that she sustained occurred in the course and scope of her employment. This case has
significant... There is no question about whether she was in the course and scope of her employment. Why is there a need for a determination by the Division of Workers' Comp? In other words, she's not seeking benefits, employer-related benefits, workers' compensation benefits.
The 13th Court of Appeals in this case stated that because the merits of that negligence claim do not hinge on whether she's entitled to benefits, therefore the Division of Workers' Compensation does not have exclusive remedy over that issue. But they're wrong, because if the Division of Workers' Compensation determines that she was in fact in the course and scope of her employment, then her negligence claim is barred by Texas Labor Code 406.034.
Right, but that's a defense that can be used in any context by an employer against a claim for damages under the common law, correct? So she can bring a suit and you can raise the defense that she was in the course and scope of her employment, and so it was a work-related injury, right? And so why the need for an administrative process if the injured employee hasn't brought a claim for workers' compensation benefits?
Because in this case, the respondent has agreed to that. The Texas Workers' Compensation Act does have a means of opting out of it if she sustains an injury and she does not want the Division of Workers' Compensation to have exclusive jurisdiction. She could have opted out of accepting those benefits.
Well, she didn't make a claim for benefits under the under that rubric, right?
But-
But the question is whether she is in the course and scope. And if she's not in the course and scope, she has no claim, right?
If she is not in the course and scope, then she has no claim against the workers' compensation benefits, and she can proceed forward.
Right, she has, if you're an employee and you're injured somewhere not in the course and scope of your employment, you cannot bring a claim for workers' comp benefits.
That is true.
Right. So in this case, she's saying, I was not in the course and scope, right? And
Yes.
and then you can say in defense, yes, you were, and so you're not entitled to any claim against us. It's barred. But I'm not understanding the idea that if someone hasn't sought a claim for benefits, that they have to go through an administrative process to get that determination.
Because the administrative process was an agreement between both her employer and herself. In this case.
For work-related injuries.
That's right.
Right?
And
she's saying this is
that it's not.
I was walking through a parking lot.
But the determination, because there is a question of fact over that very issue.
Well, I'm not sure there is, because your side told the Court of Appeals that the injuries were not in the course and scope of employment.
That actually, Your Honor, is incorrect. What
Well,
the Court
the
of
quote
Appeals-
was, you're not saying that she was within the course and scope of her employment at the time of her injury, are you? Answer, no, I'm certainly not.
Okay, so first off, that's a misquote of what the court asked. The court asked if I was arguing that, and I wasn't, because what I was arguing, the next line is that the court did not have the jurisdiction to make the determination. Whether or not Ms. Oteka was in the course and scope of her employment is not the issue before the 13th Court. It's not the issue before this court. The issue before this court is whether or not the district court in a negligence claim has jurisdiction to make that determination.
So is there any other area of law where, in this case, there was, you all pleaded an affirmative defense that the exclusive remedy provision was a bar, or Mr. Rodriguez did, I guess, the police officer. And then both sides teed that issue up on summary judgment to be resolved on the merits, and whether the exclusive remedy provision would apply or not, and because of the course and scope issue. And then only later did UT Rio Grande Valley file a plea to the jurisdiction saying that this is a question over which the division has exclusive jurisdiction. Is there any other case where a defendant just needs to plead a merits defense and then the plaintiff automatically loses because of a defense that the defendant has raised? I've never seen a plea to the jurisdiction work that way. So can you help me with that?
Well, it's not, in fact, that the respondent loses. It's that basically the determination needs to be made prior to them bringing this defense, prior to them bringing their common law defense, is that the division has exclusive jurisdiction over issues not just of whether or not an injury did occur in the course and scope of employment, but whether it did not, because the division does have the expertise in that area, and that is what the legislature intended when it wrote the act.
I think what we're getting at is here the injury occurred in a parking lot immediately following a school event.
Yes.
But what if the two individuals were co-workers at the university but also good friends, and they decide to take a weekend trip together, and on Sunday morning they're driving back and the one who's driving negligently runs off the road and injures the passenger? They're co-workers, but they're clearly not doing anything work-related whatsoever. So the passenger sues the driver for those injuries. Can the university come in and say, no, you have to sue us, but first we got to go to the Division of Workers' Comp and get a determination that this was not in the course of scope before you can even sue us? Because it sounds like that's what you're arguing. And I think your answer is going to be, well, no, because nobody's arguing in that case that it was course and scope. But to me, that just begs the question, okay, but if someone does argue it, who decides first? And why in the world would the division have to decide first in that hypothetical case?
So in that hypothetical case, I believe that the division would have to decide first, because the division has the exclusive jurisdiction over issues of compensability and whether or not someone was in course and scope. However, the legislature built into the act certain sanctions against bringing either fraudulent or unwarranted cases. In Texas Labor Code Chapter 415, actually it's Chapter 415, but specifically in 415.009, it is a violation to prosecute, defend, or bring an action that has no basis in fact or law. And then in 415.021, it explains what violation, what the sanction would be. And it could be $25,000 a day. So it is not insignificant if someone were to try to bring this false claim. The second issue is, assuming that the case is as egregious as you say it is, well, then in that case, the injured employee who was not in their employment would prevail. And all we've done at that point is just delayed the proceedings, because the division is going to find that they weren't in course and scope, and then we end up right back where they started in the district court on the common law defense.
And
If everyone agrees that it's not course and scope, do they still have to get the decision by the division?
If the parties agree that it is not course and scope, and I'm going to be honest, nobody raises the issue, then no, I don't believe they
But you
do.
say that it's jurisdictional and can be raised for the first time on appeal. And so if you don't go to the division on the ground that the employer says, yeah, I agree, it's not course and scope, you could be in exactly the same situation a year, 2 years, by the time you get to the Texas Supreme Court, 7 years later.
This is true, and I believe in cases where, because it is pretty rare that somebody is suing their employer for an injury that occurred that was not, I mean, it's just a rare situation that would come up. But if there is like in this case, there was a question at the onset of whether or not she was in course and scope, because the clerk's record reveals that the university had been trying to get in touch with Ms. Oteka to find out what happened, and she just refused to talk to them. However, you don't necessarily have to go through the entire administrative process. There are several steps in the administrative process, and the first step is either the acceptance or the denial of the claim. However, if the parties agree on a form that's a benefit dispute agreement form that the division provides, they can agree that an injury was or was not. And then the division reviews that form and signs off for it. If they sign off on that form, that is a final decision. And that can happen in a matter of days.
But you have to do that. You can't just, we all agree this is not even remotely related to course and scope.
Again,
we're just going to go to court.
I think if there's a question, I think it's probably best practices, because otherwise, if there's a question, yeah, you can end up with this jurisdictional issue months or years later. I mean, there are actually several cases in which 2 years later, issues of course and scope are coming up after an argument.
That may well be best practice, but we also have a pretty strong presumption against the ouster of jurisdiction by a district court. And we've said that over and over again, that in order to say that an administrative agency or some other court has jurisdiction to the exclusion of a district court, you have to have text that is unambiguously clear as to that ouster. What text is it that you are pointing to allow us to say that a district court lacks the jurisdiction to determine whether or not a negligence claim can proceed in the district court?
Well, Your Honor, whether an agency, this court has stated that whether an agency has exclusive jurisdiction on a statutory is a matter of statutory interpretation in Subaru v. David McDavid. So in this case, it is and has been this court's
But I think he was asking
interpretation.
about the specific text that you're relying on.
The specific text in this case is Texas Labor Code 402.001 and 402.002. Basically, I'm sorry, I'm looking for the language now. But
Well, they talk about whether you're, the exclusive jurisdictions over the question about whether you're entitled to workers' compensation benefits, right?
the Texas Labor Code basically lays out a rubric of how you get to that, the answer to that question.
But, and what we're talking about are really two distinct questions, right? And so I think the language you're talking about is referring to one, but where do you get to the other? That's what we're trying to get at.
Yeah, so if the question is what specific language says the Division of Workers' Compensation has exclusive jurisdiction, I would say that that specific language is not in the statute. However, it has been interpreted by multiple appellate courts as well as this court on multiple occasions.
But it's been interpreted to say that the entitlement to workers' compensation benefits is what the division has exclusive jurisdiction over. And what we're trying to figure out here is the logically prior question of whether there's even coverage for workers' compensation under which you could even claim benefits. So that's the question we're at. The coverage question is the one, whether you're in course and scope or not determines whether you're even covered by the policy, right?
It is one of the criteria, yes.
And so in Garza versus Exol Logistics in 2005, we decided that question and said that an employer was not entitled to a defense because it did not establish that it was covered by workers' compensation insurance. Under your theory, I guess Garza was incorrectly decided because that was a question that was exclusively within the jurisdiction of the division.
I actually, if I'm hearing you correctly, I actually believe that that's actually a different question because, again, this...
Well, it's also a coverage question, and it seems like what you're saying is all coverage questions, whether it's course and scope or something else. Did you pay the premiums? It seems like all those questions, if coverage questions are exclusive jurisdiction, then they're all going to have to go to the division.
Well, not all coverage questions are exclusive jurisdiction, but questions concerning the entitlement to benefits is, like whether or not...
Well, you're not entitled to benefits unless there's coverage.
This is true, but if the question is, did the employer have workers' compensation coverage, or was the injured worker an employee of that employer? The court has multiple times found that insurance coverage questions like that are not within the exclusive jurisdiction.
Counsel, could I come back to Justice Young's question? So on page 12 of your blue brief, you say, the legislature has vested in DWC the exclusive jurisdiction to determine whether an employee is entitled to workers' compensation benefits under the Act subject to judicial review. And you cite Texas Labor Code section 410.001 et al. And so can you read me the language that would have been in your brief there?
Okay,
what statutory language, because if this is a jurisdictional question, then I assume we would have had to have caught it. We would have that sua sponte obligation, even if the able counsel that are in front of us here hadn't caught it. And so what language in the statute did you have in mind when you cited 410.001 et al.? Okay.
So the Chapter 410 is the administrative procedure over which the division determines issues of benefits, including course and scope. Specifically, 410.251 indicates that once the issues are exhausted in front of the Division of Workers' Compensation, then you have a right to judicial review of those issues. And the judicial review of those issues is not the same judicial review that you would have if you had just immediately gone to court with your question, because it is a modified de novo review. And pursuant to 410.251, once those issues are exhausted, those are the only issues that can be brought before the district, the district court at that time. And under the modified de novo review...
Your time has expired. Are there any further questions? Thank you very much, counsel. We will hear from the respondent.
May it please the court, Mr. Messina will present argument for the respondent.
Thank you. May it please the court. I want to start with making it abundantly clear that in this matter, Ms. Oteka did not bring suit against her employer. She brought suit against a police officer who was negligent and caused her some very severe personal injuries. Obviously, the road to where we are now included the defendant's right or the state's right to substitute in her employer, who happened to be the same employer as the tortfeasor. Ms. Oteka has not ever asserted that her employer was negligent or caused her injuries. Ms. Oteka has never asserted that, and didn't have to assert when she sued the police officer, that her employer was vicariously liable for those actions because...
But under the workers' compensation scheme, it's a no-fault scheme. So if her injuries were work-related, and she was within the course and scope of her employment, there is not a claim against her employer other than a claim for benefits under the policy, right?
I think the case law is very clear, and this court has been consistent throughout all the holdings that that's true. The division has exclusive jurisdiction over the entitlement to benefits, and we're not disputing that at all. In fact, but the basis for doing that was this court has said over and over again that the purpose of the Workers' Comp Act was to systemize it, make it a fair playing field, not have to prove liability.
Aren't those two issues about whether a person is entitled to benefits and in a situation where course and scope is an issue, aren't those very intertwined? And can you separate those out? Because it's not just a matter of, is this really an employer? Is this really an employee? There's other things that can come up, right?
I think I understand your question, but basically you're saying, is there a course and scope requirement or finding requirement at the division level, but yet there could also be one at the trial court level?
Well,
Yes.
it's more simple than that.
Yeah.
Can she be entitled to workers' comp benefits if she was not within the course and scope when she was injured?
I do not believe so.
Right. And so in order to determine whether she's entitled to workers' comp benefits, there has to be some showing or determination that she was in the course and scope. And so when we said in American Motorist Inc., the Fodge, Henry versus Dillard Department, when we said that whether the claimant was entitled to workers' comp benefits is a matter within the commission's exclusive jurisdiction, why doesn't that make the course and scope question a matter within the commission's exclusive jurisdiction?
Because in this case, her claim, or she didn't make a claim, but the carrier sent her a denial letter 33 days after her incident. It's in the record, and that's why I did an exhibit notebook. It is the timeline of what happened. She got hurt on May 11th, I believe, and on June 14th, she receives a letter from the carrier. It's a PLN1 that says, based on our investigation and the information currently available, we deny any injury or occupational disease arose out of and in the course of scope of your employment.
Right, and the next sentence says, and you're some reference to the fact that she had decided she was only going to take personal insurance.
Well, keep in mind, and I think
that was all part of their determination. Okay, well, look, if you don't want benefits and you're just going to rely on your own personal health care insurance, then we're denying any claim to benefits.
And I know they've glossed that and called that an opt-out. And I submit that it's not, because it's in 30 days after she was severely injured. They did have conversations. It references phone calls, the emails and the exhibits that I produced for you. They were in contact. And as Ms. Oteka said, I notified my employer because I was going to be out of work. I wanted them to not be concerned at my injuries that occurred.
I think the university's point is that when you receive the denial of benefits from the carrier, there's an appellate process in the workers' compensation system that goes through the Division of Workers' Comp. And that is the process that a plaintiff is required to avail herself of before bringing suit in court. And that's sort of what the First Court of Appeals held recently in Prentice and Lake Management Services. So I wonder, is it not, their position that you've got to exhaust your remedies within the system first?
What that does, though, to a party who receives a denial letter, a PLN1, is it then requires the party who was told they don't have benefits to go to the division to open a claim to affirm a denial, to get a negative finding.
But if we don't do that, if that's not the case, isn't it going to just do away with the whole with the whole scheme of having this area of the law that's to be determined largely through this regulatory agency, through workers' comp?
I don't think so. I think that.
Well, explain to me why that wouldn't be the case.
Because if there was a denial letter early on,
So you're saying it should just be limited to when there's a denial letter, we're going to have a carve-out for those?
I would think it's opposite. If you have a denial letter, why would you go, it defies the efficiency that the court has supported about the Workers' Compensation Act for years. Why would you go open up a claim with the division to prove a negative?
If
you're
you
the
didn't
claimant?
have a denial letter, would the outcome here be different?
I think so. I think if you didn't have a denial letter, and someone initiated the workers' compensation process. She didn't, but her employer has the right to do that. Had they done that, the jurisdiction of that issue rests with the division.
What difference
not what
does it
happened.
make that your client, through her lawyer, signed a Rule 11 agreement to allow the employer to step in, thus essentially acknowledging that she was in course and scope under 101, 106?
I have questioned myself on this a lot for signing that Rule 11. However, the statute 101 that they used for the basis to substitute the employer in for the officer, because remember, this is Texas Tort Claims Act, it's not negotiable. You can't object to it. That Rule 11
It's
does.
an acknowledgement that the police officer was in the course and scope,
Well,
not an acknowledgement about your client.
It's actually an acknowledgement that he was in his official capacity as a police officer,
Right,
which
but
is the requirement.
did the Rule 11 affect her position?
No.
No.
I would not construe that as an admission or agreement that she's in the course and scope of employment. They can substitute in as a party for the officer, which is, by the way, the only party she wanted to bring suit against, the negligent party. And so I've heard arguments, I've read briefs about we don't want employees suing their employer. Well, that didn't happen in this case. They substituted in with a mechanism that she can't stop. She can't,
Well,
there's
what
no
if-
objection we can make.
What if you were allowed to proceed in court with this claim and you got a determination that, in fact, the comp bar applies and you lose because the actors were in the course and scope? Would you then be able to go and claim benefits? Why or why not?
I don't specialize in comp, but
Because that seems like
Typically- No, no,
like
I
there'd
would
be room
typically
for
say no.
gamesmanship there and a second bite of the apple and sort of undercuts the very reason we have the scheme in the first place.
my general response to that would be no. And that's probably a risky run while fighting the affirmative defense that's asserted by the defendants, which typically they have the burden of proof. If a defendant asserts an affirmative defense, they have the burden of proof. What the AG is arguing here is that, oh no, actually, you have to go to the division and disprove the affirmative defense and show that you're not in the course and scope of employment. That's what, it shifts it completely. So if they're correct, why would you have an affirmative defense for course and scope and exclusive remedy? That is there. And frankly, we spent a year after that substitution of the party doing discovery on that very issue, on course and scope. Took depositions, did discovery, looked at policy manuals, looked at her contract. That's what I tackled. That's the first thing I went for. And that's why I filed a summary judgment on the issue, because it was good evidence that indicated there was no course and scope. But for that battleground to have to go, for her to have to go to the division to have that battleground defies the purpose of an affirmative defense.
So I'm not a workers' comp lawyer either, counsel, so this is just a hypothetical, but suppose instead of Professor Oteka, she is Officer Oteka, and she was working traffic control at the graduation, and Officer Rodriguez hits Officer Oteka with the cruiser, causes the same injuries that are alleged here. How does that much simpler case, how does that one come out, and are we going to end up in front of the Division of Workers' Comp there?
I think it depends on what the adjuster at the comp carrier does with that. And I don't know that it legally changes. I don't know if there's a legal issue
What
that
does
changes.
it depend on? And so my recollection here is that Professor Oteka responded to whoever in the HR department contacted her, or whoever from the compensation carrier, and said, I have private insurance here, and then that was why the coverage was denied. Is that right?
That may have been part of it. I don't know if I'm willing to say that's why. I think there was a lot of discretion exercised by the adjuster based on whatever information she was gathering or tried to gather.
But
to make a
your
decision.
answer to my question for all these soon-to-be lawyers here is a good one that a lot of careful lawyers will give, which is it depends. So what does it depend on, and what would it take for Officer Oteka to win in my hypothetical question?
I think the law would be the same. I think it depends on if the workers' comp adjuster accepts or denies a claim based on that fact pattern, which is a different fact pattern.
But if the denial is on the basis, look, I've got my private insurance, that's how I want to do it. Okay, fine, denied. That is a King's X, and now you can go to court under any circumstance.
I actually don't agree with that.
Well, I thought you said a little while ago that the only difference you had with your friend on the other side was that there was that initial denial here, and that the state is right. But for that initial denial. So if you didn't have that initial denial, then yes, the division has the exclusive jurisdiction. You have to go through all that. You can't go to court. But if you get that initial denial, which can apparently be based on your statement that you have your private insurance, which is how you want to handle it, then you just now can bypass the administrative process and go straight to court.
I think it comes down to whatever adjuster who's making that decision determines as a basis to deny. As counsel has pointed out in their briefing over and over, the insured employee can't opt out at that stage. It's early of your employment, you opt out. So if you're a professional overseeing a workers' comp claim and you have an insured or an employee that says, well, I have private insurance, and you interpret that as an opt-out, I think it's a mistake.
Well, you can't opt out, I suppose, of the workers' compensation system to get into court, but do we force people to take benefits if they don't want them and they say, no, it's no big deal, I've got private insurance, I can go to my doctor, everything's gonna be fine. Does the law say, no, you will take these benefits? Is that an opt-out that's not permitted?
I don't know if that's if an employer or more importantly, the insurer can force the issue on a
Well, it seems
employee.
like there's two different inquiries that are going on. The workers' comp administrative process looks to whether there was a compensable injury. And so a lot of things can go into that, including, whether the employee opts for private health benefits. May have had an injury, not compensable for these other reasons because of the terms of the policy. The exclusive remedies provision really only directs the inquiry to whether the injury was work-related. And so it seems as though the two inquiries are different. And why would the one about whether the injury is compensable be a jurisdictional bar to the other, which is whether the injury is work-related?
Because the division was given that right. The division was given that right to determine compensability.
Right,
under
but I
a
think
plan.
you're arguing that it's not, the division's not the exclusive
Oh,
determinant.
absolutely not
Right,
in that
yeah.
situation. And
So-
it's more than just course and scope, though, on the exclusive remedy affirmative defense. It's actually, you had a right to workers' comp because it was course and scope. But the first test is course and scope. So, yeah, I don't think.
But that brings me back to the question I asked first, which I don't think I quite got an answer to, which is, if we have said, and we have repeatedly said, that the commission has exclusive jurisdiction over the issue of whether a person is entitled to workers' comp benefits, and if entitlement includes compensability, employer-employee relationship, and course and scope at the time of the injury, why doesn't that necessarily mean the commission has exclusive jurisdiction over course and scope? I mean, I think you're making, and I heard Justice Busby sort of suggest this earlier, and I'm hoping someone will flesh it out, is how is course and scope not part of the entitlement question? How can we separate those two?
I think the appellate court nailed that, and that is for a personal injury claim, for her to have rights to a personal injury claim, it doesn't hinge on a finding of compensability. And also, the claim in the district court's not tied to an entitlement to compensation. That's why.
And I think what you're really arguing is, look, if I file a personal injury claim, a negligence claim, then whether or not I'm entitled to workers' comp benefits is not at issue. And therefore, the commission does not have exclusive jurisdiction. But the problem is the defendant comes in and raises the bar as a defense, and that creates the issue, the entitlement issue. And entitlement encompasses course and scope.
Well, they're raising more than an entitlement issue. They're basically saying that the only party who can determine course and scope is the division in any situation.
Right, well, what they're saying is you can't sue us for negligence because you're entitled to workers' comp benefits.
I think what they're saying.
And you're saying, I'm not entitled to workers' comp benefits, I wasn't in course and scope. That creates the issue, their defense creates the issue over entitlement. And we've said over and over again, entitlement falls within the exclusive jurisdiction of the commission.
I think they're arguing that it's not that an entitlement issue, it's that because the division has exclusive jurisdiction on entitlement, but necessary to get entitlement, they have to evaluate course and scope.
That's
and
what I'm
that's why
saying.
they get it in all cases. So in that world, they assert the comp bar or the exclusive remedy affirmative defense. It requires, they're saying if we assert that affirmative defense, then that trial court doesn't have jurisdiction on the issue of course and scope. Forget about entitlement. They're saying you don't have jurisdiction on course and scope.
So maybe, does it help that we've also said that coverage issues are for the court to determine, but entitlement issues are for the division to determine? And so how do we distinguish between coverage issues and entitlement issues?
Well, there's a mechanism in place in the workers' comp process that if there's...
Now, outside, how does the court determine, before, the court that you were before, how do they decide whether this question about course and scope is a coverage issue or an entitlement to benefits issue? What's the test for that? Should we look to general insurance law to help us flesh that out?
Yeah, so you're saying, is there a coverage question in the district court case, for example, of whether she is or is not entitled to benefits?
Yeah, I mean, there's all sorts of coverage questions, right? Did they pay the premium? What is the insurance cover? Are they within course and scope? Could be a coverage question and not an entitlement to benefits question.
I think I would at least originate in the division, and then ultimately it can be appealed to the district.
Seems like that's against your position.
It's not, because it's a course and scope finding is the issue that we're having on. It's not interpretation of entitlements.
Should we look to arbitration law for an example, for an analogy here, where courts decide whether there's an agreement to arbitrate, but whether something's within the scope of that or not goes to the arbitrator, and so that maybe this is more like a question of, is there insurance that covers this, so that there's even something for the division to think about? Because if there's no insurance that covers this, then there's never going to be a question about entitlement to benefits under that insurance.
I think the more important issue is, can you assert an affirmative defense and strip the district court of jurisdiction because of this supposed exclusive jurisdiction to determine course and scope at the division? Entitlement under the contract seems like a different issue, and I don't know about going down the arbitration road.
If you have a situation where you're in court and everybody seems to think that's fine, and then it comes up for some reason that course and scope is an issue, would it be proper for the court to abate the lawsuit and allow the division to address the newly arisen but potentially jurisdictional question?
You would certainly hope so, especially if you take this case. Look at that timeline of the exhibits that I provided, that there's a denial 30 days after the incident, and then 2 years later after we file a summary judgment, and in fact, they got a hearing on the plea of the jurisdiction before they filed it, which is odd. There's a letter renewing a compensation to the plaintiff, or to Ms. Oteka, The next day, that's the exhibit to the repleted jurisdiction. It's Exhibit 12, the last exhibit. It was written, ready, waiting on the letter. Yes, the remedy that they should have asked for, the fair thing at a minimum, aside from how unfair that process is, would be at least abate the district court for that. They've sought dismissal in this matter.
Any further questions? Thank you, Mr. Messina. Ms. Tripp, I believe you have 5 minutes.
Thank you, Your Honor.
And I wonder if you could start by addressing that point. If we were to allow abatement in a circumstance in which course and scope arises, would that not simultaneously advance the interest that you're pursuing of the exclusive jurisdiction of the division without having the unfairness of dismissal with prejudice?
I actually think that that is exactly what should happen in this case, assuming the respondent intends to go through the administrative process.
So your request was for us to dismiss with prejudice, but you're modifying that to allow for abatement?
Yes, Your
Okay.
Honor.
Along those lines, your friend on the other side mentioned that there's a way for the employer to put this issue in front of the division. Is that your understanding? And if so, how does that work and where does that come from?
So I'm going to be honest, I've been a workers' compensation attorney for 30 years, and it has been my experience, I cannot say this is an absolute, but it has been my experience is if there is not a dispute on the claim, then the insurance carrier cannot go to a hearing because the division will not hear it. In this case...
Well, that's going to be a problem, right? If it's jurisdictional, because they're going to have to hear it.
Well, but
even if there's no dispute, because then years later you could come back and challenge the judgment as void because there's no jurisdiction.
But the dispute on the claim, so in this case, since the claim has been accepted, it would be very difficult for UT to say to the division, we want a hearing to resolve this dispute.
You say the claim has been accepted. Do you mean that it's now the position that she's entitled to workers' compensation benefits?
Yes, and my understanding...
In contradiction to the initial denial of the claim?
Yes.
So why wouldn't, having received the denial of the claim from the insurance carrier, why wouldn't that sufficiently exhaust that process? In other words, okay, they denied it. I don't really want to change that outcome because I think I wasn't in the course and scope, and I have a remedy in state district court. And so I'm going to go ahead and pursue that. Why did there need to be further activity by her in the administrative process?
Because an initial acceptance or denial of a claim is not the end of the claim. It is actually the first step in the administrative process.
But wouldn't it have been your job to say, no, we're not denying, we're accepting immediately, not 2.5 years in?
Yes, but in this case, as you can see from the evidence in the clerk's record, specifically pages 348 through 358, is that Ms. Oteka refused to give the university the information they needed to make a determination. They had tried multiple times to get her to converse with them, and then she said, no, I'm just not going to pursue this. That was not an invitation to sue the university in negligence. She has waived that common law right under Texas Labor Code 406.034.
So if the insurance company says no coverage, do you have the ability as the employer to challenge that at the Division of Workers' Comp and say, no, we want the comp coverage to apply so that we get the benefit of the exclusive remedy provision?
Yes, there is actually a mechanism for that, but in this case...
Why isn't that the simplest way for this to proceed, and parties in your position can do that if they choose to, and otherwise the case goes on?
Because in this case, early on, what information the university have? Not much, because Ms. Oteka would not talk to them. It wasn't until she filed the MSJ and actually put forth an affidavit as to what happened. That was the first information of a statement from Ms. Oteka that the university had. At the onset of this case, because of her refusal to explain what happened, explain where she was, explain what was going on, the university had no knowledge. And when you look at the denial, it basically states, this is based on our investigation and information currently available. It wasn't until after the MSJ, when they got the additional information and then went to see whether or not they could confirm what she was saying, if the evidence met that, that they determined to take a second look and accept the claim. I would also.
It sounds like you're arguing now that she all along was in the course and scope of her employment.
Well, she was. The denial doesn't mean she wasn't. It means that the information available at the time, the university had no reason to accept it because they did not know, and she would not talk to them. There were multiple emails. They sent her forms. Just fill out these forms. The forms actually have the information that they would have needed to do their investigation, and she refused. They did not think that she was laying in wait to hit them with a common law negligence defense. They just assumed.
Well, that doesn't seem quite fair.
I'm not saying.
He sued the officer. She sued the officer.
Yeah. And, I would also state that, because I know that there was a question earlier about whether or not an employer or a carrier could force her to accept benefits. There is in the Texas Insurance Code, Chapter 1305.006, there are workers' comp networks. And while an employee who was injured in comp is basically required to use those network doctors, if they don't, then those medical documents will not get paid. None of those bills will get paid by the insurer or the employer. So we can't force her. In this case, she said, I'm going to use my private insurance. We could not force her, because if she had used workers' compensation doctors, then we would have been receiving the medical, and we would have been able to review what the medical document said to try to get a better idea of what had actually happened in this case. But she was going through separate doctors.
Counsel. Are there any further questions? All right, thank you, Ms. Tripp. Thank you to all counsel for joining us here in Waco. The case is submitted, and the court will take a brief recess.